I'm deeply worried about this bill. When I was driving up from West Cork this week, I was trying to think about how I could convey my very profound concern for what the government is doing. This bill will have far-reaching consequences for disabled people, for older people, and for individuals experiencing mental health difficulties. It affects how they can make decisions about their lives. This bill should have been developed in partnership with disabled people. Instead, it is being rammed through, ignoring their calls for a transparent and a collaborative approach. Not only is this morally wrong, it is an obvious breach of the Convention on the Rights of People with Disabilities. This bill should be about structures that presumes individuals have capacity and empowers them. Instead, disabled people and human rights experts are warning that it is establishing a system that enables discrimination, exclusion and abuse. Crucially, the government is allowing a process whereby a large number of unqualified people can make assessments of an individual's capacity. For example, a bank teller could decide that a disabled person or an older person cannot have access to their own money. This is a terrifying prospect that not only breaches rights, but pushes disability rights back about 20 years in this country. There are numerous other issues with this bill, including a clause relating to medical procedure that goes against the repeal of the 8th Amendment, continues to exclude many disabled people from jury service in a discriminatory manner, and retains an assessment called the Functional Test of Mental Capacity, which has been deemed a human rights violation by the UN Committee on the Rights of Persons with Disability. The bill is being rushed through without inputs from those it affects. This bill breaches the rights of disabled people and will create further discrimination. This bill will be the subject of suffering, litigation and dispute for years to come. On each occasion, people will look back and ask, how was this allowed to happen? Minister, you need to stop this now. You need to listen to disabled people and human rights experts. The most glaring issue in this bill is the disregard for the perspectives of people with disabilities. Article 4.3 of the Convention on the Rights of People with Disabilities states, in the development and implementation of legislation and policies to implement the present Convention, state parties shall closely consult with and actively involve persons with disabilities. The Government and the Department of Children have knowingly and therefore intentionally breached this article. In the development of the bill, and in the determination to ram it through this House, it is violating an international human rights convention. The Children's Committee's report highlighted that a significant number of stakeholders highlighted that there was no public process organised by the Department to engage with disabled people organisations, family carers or other relevant persons, and that there is no plain English or easy-to-read version of the bill. These are not only significant barriers, but they are representative of the institutional discrimination. Joe McGrath, a committee member of the National Platform of Self-Advocates, articulated this issue very well, and here I'll quote him. "This law is very important for us, but we have not been given enough information about it. Since the law was passed 7 years ago, no one from the government has told us what we need to do to get ready for it. This is not good enough. Everyone has the right to know what the law means for their life. There should be an easy-to-read version of the law so that we can understand it for ourselves." In essence, this bill has been developed, designed and written with no meaningful input from disabled people, disabled persons organisations and others affected. The Justice for Wards group have also highlighted a lack of engagement. In the pre-legislative scrutiny stage, officials from the department revealed that they were using a decade-old consultation. Not only is the Minister obliged to engage with these groups, they are enthusiastic to be heard. They have been proactive in attempting to engage with the department, but have been ignored. Disabled persons organisations, older people's groups, mental health reform are all eager and available to help work with the department and the Decision Support Service. Intentionally disregarding their wealth of lived experience and shared knowledge is disgraceful, as well as a violation of the Convention of the Rights of People with Disabilities. The speed at which it is being rushed through compounds the harm being done. The 70-page bill was published on Friday evening. It's being discussed today and tomorrow, with amendments due next week. I'll be honest here, I don't understand half of it. It's written in extremely dense language which can only be understood in conjunction with the original bill. In such a short time frame, I do not have the capacity to engage with it all and to draft proper amendments, and it is my job. I'm relying on the expertise of others to help me understand this, in particular the Centre for Disability Law and Policy in NUI Galway. What chance is there then for those directly affected? Campaigners have asked for time to engage with the bill and for an easy-to-read version. What is the Minister's response? It can't just be to ignore them and to move on. This is so wrong, it is bad lawmaking, and it is something we shouldn't even be talking about in 2022. The Children's Committee is also part of this problem here, and we acknowledge that our PLS process was less than exemplary given the very short time frame we were given. As such, it cannot be considered to represent meaningful and inclusive consultation on the bill. Reflecting its development without enough input from disabled people, the legislation does not recognise the need for meaningful engagement with people directly affected by this law. It delegates powers to the Decision Support Service without mandating that office to engage meaningfully with disabled people, older people and people with experience of mental health services in exercising these powers. During pre-legislative scrutiny, it became clear that the Decision Support Service had not been meaningfully inclusive of disabled people in the drafting of their codes of conduct. This is worrying for two reasons. Firstly, the practical implementation of this bill through codes of practice for assisted decision-making have had no real input from those affected. It is a blatant example of a paternalistic understanding of disability that ignores the agency and rights of disabled people and older people. Secondly, it reveals that a paternalistic and non-inclusive culture already exists in this new office. It is essential the bill compels the Decision Support Service to work in conjunction with those affected. The pre-legislative scrutiny report recommends that the Decision Support Service must progress and intensify meaningful engagement with disabled persons' organisations and other stakeholders in the development of guidance, resources, and must assign the necessary resources to achieve this in a timely manner. The requirement must be added to the law to ensure the Decision Support Service complies with the Convention on the Rights of People with Disabilities and respects disabled people, older people and people with experience of mental health service if this new office is to have any credibility. All of this comes down to having the decency to engage with those affected and following the state's obligations under the Convention. Again, quoting Joe McGrath of the National Platform of Self-Advocates, "We want the government, the minister, the department and the Decision Support Service to listen and work with us. Nothing about us without us." Minister, there are several issues within the law or absent from the law that need addressing. The first issue is fundamental to the whole framework. The bill does not go far enough to guarantee presumption of capacity, which is the purpose of this bill. The law should operate from the position that all individuals have capacity unless it is proven otherwise, similar to innocence in our legal system. This bill, while designed to support people, also gives the right to remove or restrict a person's decision-making capacity. It's an incredibly serious power that needs to be very tightly controlled and limited. Only the courts should have that power. A court has the capacity to listen to medical, legal and other experts and family to make an impartial decision. This can and should be the only way decision-making should be removed from an individual. The committee heard wide-ranging concerns as to how this principle needs strengthening in the bill. At all stages, relevant persons should be presumed to have capacity unless a court decides otherwise. The obligation must be on other parties to establish a lack of capacity rather than the relevant person having to prove their capacity. Independent Living Movement Ireland were very clear on the need for the bill to provide for the presumption of capacity and the protection and promotion of the person's will and preferences. They called for specific reference in the legislation about the aim of the legislation to ensure autonomy of disabled people to live the lives of their choosing. During pre-leg, stakeholders raised issues with the Decision Support Service's draft codes, that a wide range of actors, including legal practitioners, financial professionals and healthcare professionals, can carry out assessments of capacity as they see fit. These individuals can then make decisions about whether or not to respect the relevant person's decision based on their own assessments without any resource to or oversight by the courts. This simply cannot be allowed. It is highly problematic and dangerous, a proposal that gives a whole range of people, possibly well-intentioned, with the power to remove or limit an individual's decision-making. This is incredibly worrying and irresponsible. I gave the example earlier of a bank teller being given the power to stop a person with a disability or an older person withdrawing money from their own account. Minister, the standard has to be a presumption of capacity, and it is up to the state and others to prove otherwise in court. This principle must be embedded in the legislation. It is not sufficiently articulated currently, as evidenced by the Decision Support Service's own draft codes. The second issue concerns what is referred to as the functional test of mental capacity. This practice has been deemed incompatible with Article 12 of the Convention on the Rights of People with Disabilities. The functional assessment of capacity typically focuses on if a person is able to understand the information and use and weigh the information relevant to the decision. General comment number 1 of the UN Committee on the Rights of Persons with Disability clearly states that it should not be used to deny someone's rights and recognise it as an unreliable method of assessing inner workings of the human mind. It discriminates on the basis of disability and has been recognised as a subjective method of assessment, with individuals receiving different results depending on the person conducting the assessment. It's truly shocking that this hasn't been removed from the bill. Again, the committee's recommendation was very clear. The bill should remove the functional test of capacity and replace this with an obligation to acknowledge, interpret and act upon the relevant person's will and preferences in line with the UN Convention on the Rights of People with Disabilities. Thirdly, the bill does not remove a section of the original bill which reflects the pre-repeal situation. Under Section 85(6) of the 2015 Act, an Advanced Healthcare Directive would not be valid or applicable if they contained a refusal of treatment which would have a deleterious effect on the unborn. An Advanced Healthcare Directive is a statement you can make on the type of medical or surgical treatment you want or do not want if you're unable to make these decisions in the future. However, under the 2015 Act, parts of an individual's Advanced Healthcare Directive are limited to the treatment who would have deleterious effect on the unborn. A person's will to receive a required treatment is restricted in this case if they are pregnant. These sections are the language of the 8th Amendment and have no place in a post-repeal Ireland. As pointed out by Professor Eleanor Flynn of NUIG, these sections are simply unnecessary and can be deleted from the legislation. It's welcome that there appears to be a will to do that from the Minister, but how was it included in the draft that we got this Friday? I think it's evidence of how rushed this legislation has been.